Hello, everyone. My name is Lily, and I wanted to come here today to talk to you about the case of baby girl Delilah. This case is hitting close to home for me because it happened nearby in the same state I live, and also because once I read the articles about it, there was information that she was removed from the parents by child welfare services and then returned. And a few weeks later is when she passed away. So the reason why I wanted to talk about it is because I'm a child welfare services worker, also known as CPS or DCFS. And part of my job is helping families that are going through a removal of their children. And I wanted to kind of explain a little of the behind the scenes. Now, I don't have any actual inside information on this family. I am not currently working because I'm on medical leave to help deal with my mental health. This is also part of why I started this channel, to kind of process a little bit of my feelings, my progress, what I'm doing, and see if this is something that I can have kind of like an extra hobby or something to give more purpose to my life and help me deal with the stress of the job. Now, I have zero editing skills. This I don't record things, so you're gonna hear lots of noise, and I'm gonna be distracted looking all over. Hopefully I don't knock over my lamp again because I just had to start over. And I'm gonna try to keep focused on you. So I wanted to start with, what's the story, what's going on. Last week on Tuesday, this little girl, 3 months old, baby girl Delilah, was found by her parents to be unresponsive, not breathing, not waking up. They call 911. Police get there, start doing CPR. Paramedics come. They are able to resuscitate her, rush her to the hospital. She later dies in the hospital. The parents, Brandon and Elizabeth, who are 21 or 23 years old, the article didn't say who was what age or give many details. They were both arrested that same night for suspicion of the baby's murder. There has been no information released as to the cause of death, and the I'm sorry, I get confused which one's manner of death and which one's cause of death. I think I actually had them backwards. I believe cause of death would be homicide, and the manner of death they had have been released. So again, I don't have any knowledge other than what's been on the news that I was able to find online. So the reason that she was taken away from her parents at birth was due to concerns of the home being unclean or unsafe. And she was placed with an aunt. I think it was maternal great aunt, for under emergency custody, while the parents worked on getting their situation improved. And she was allowed to go back to the parents after approximately a month and a half. Now, the way that child welfare even gets involved, the very first step is we get a phone call. There has to be a call to the child welfare child abuse hotline to report a concern. That's what we would call getting a referral. Social worker gets assigned, goes out to investigate the situation. We would talk to the parents, any other family members were able to get a hold of, the support systems, neighbors. Since this was when the baby was born, they might have contacted hospital staff, everybody, to figure out what's going on and make a determination of whether there's a likelihood that the abuse is happening or not, or that there is a substantial risk to this child of being abused if something is not done right away. Now, to be able to determine that, we use the California Penal Codes for child abuse, maltreatment, and neglect. That's very lengthy bunch of different codes themselves, so I can't go into it. Plus, I don't really work that section, so I don't have them memorized. We have a little cheat sheet that we use, and I don't know it by heart. But to go from there, we don't automatically take the kids away and take them to court. To be able to take the family to court, then we would have to file or petition, or what would be the equivalent of the parents' charges, or what would be, in criminal court would be the charges. On our side as a petition, it would be under the Welfare and Institutions Code. That's separate, or it's like a sister of the Penal Code. And this has different rules. This is Welfare and Institution Codes, section 300, E, A, B, C, D, E, F. I believe up to J, I, K. I don't think there's a K, but those are two different processes. So before we even get there to take them to court, we have the ability, we have a concern, right? We are able to substantiate under the first penal codes. There is a concern that's been identified, but the family is in agreement that there is a concern, and they're willing to work with us to resolve the situation. Then we don't necessarily need to take the family to court. We are able to offer a voluntary services contract. So what this means is that the parents would agree to meet certain requirements, work with us for 6 months. Sometimes the child can be out of the home. Sometimes the child can be in the home, depending on the situation, the gravity, and the risk level. There's also, in that situation, the social worker would need to go to the home to meet with the parents and child at least twice a month. The law changed recently within the last couple of years. It used to be once, now it's twice a month, because it's a little bit more intensive than our regular cases, since there's no court involvement and we only have 6 months. And it's not guaranteed, right? The parent can refuse. This is really something we offer only to people that we genuinely believe that they just need a little extra help. So there's also another service that can go hand in hand with this, the Intensive Family Preservation Program. So in this program, there's another separate social worker that can go to the home up to 2-3 times a week and help the parents one-on-one on what they need, setting them up with resources, providing supplies for the home, maybe getting some money for rent, getting appliances, whatever the family actually needs. Like if it's cleaning that's a problem, they would get down and dirty with them, teach them how to scrub the floors if needed, get them organized, get them cleaning supplies, work really on what the issue is to make the situation safe enough for the children to return. Now, once that's what I think was a situation with this family, because it was only a month and a half. So it could be that it was still during the initial investigation phase that they were able to stabilize the situation enough to where the child was able to go back home. And this decision would be made solely on the neglect, dirty home, unsuitable home issues. Now, the statements of this family being dangerous, it wouldn't really come into play much if there is no specific allegation. So just because a parent has a past, it doesn't necessarily mean we can do something about it, or that we can correlate it to future risk to the child. It has to be very specific relation. If we know for sure the parent has harmed another child in the past, and that's been, there's paperwork that we can trace back, that we can get to take them to court, that would be something where we can act on a parent's past. But just the fact that, they're a drug dealer, or, they have a history of prostitution, or they were in a previous domestic violence situation, but there's no evidence that that's the pattern on this situation. There's many things that could happen where it would possibly be a risk, but we can't quite make the connection strongly to this particular child at this moment in time. So we wouldn't be able to take it to court and open a case. So that's what I'm thinking happening here. There is also the possibility that the case, excuse me, that the case did go to court. Okay, sorry, I had to pause the video because apparently, even though I really like talking, my throat doesn't like talking for more than 10 minutes straight. Um, what I was saying is that there's a possibility that the case could have been taken to court. In that situation, the parents, the child, they all get assigned their own attorney. My office would have an attorney, and we would have to present the case to the judge, try to convince the judge of why we believe they fall under this second section, the Welfare and Institution Code, and then each of the attorneys would give their opinion as to why it does or doesn't. There's a possibility that between there's an initial court asking permission for the child to be in protective custody while a more in-depth investigation is done. Those are usually a second hearing 3 weeks later. I believe it has to be 21 days. And in between those 2 dates, there is a possibility that the social worker office might have changed their mind, that the parents would have resolved the situation and there's no longer a need for opening a case. Or it could be that, yes, we do want to open the case, we go forward with the trial, and that the parents win the trial, and that we're not able to prove to the judge enough evidence that this child is at risk, and then we're not allowed to open a case. So it could have been either situation. Just because of how backed up the courts have been since COVID closures, I don't think that there was enough of a timeline to go through the court system. I think that it would have been still open investigation that just took a little over the 30 days to close, just because the parents were really trying, and there was like maybe weighing those back and forth. Also, I don't know if this family had any other history with us. In cases where there is a suspicion that there's more going on, the social worker's not quite sure, there's a consultation process we go through. We don't just make decisions on our own. For any little decision, we go to the supervisor. When it's something more, we can go to the manager, or we can go to what we call a multidisciplinary team. I think that's it. It's MDT meeting was what we call it, where we would have members of different programs, different levels, some community members, service partners, like the parenting class providers type of thing, to help us come up with what would be the best plan of action for a difficult case. Again, I don't know exactly what happened, so I'm in between. There was concerns. They offered the family voluntary services. They said yes. They resolved the situation really quickly. Or maybe they halfway resolved the situation and then refused to keep working with us. Again, if it was voluntary, they can always say not anymore. And at that point, the risk was mitigated enough where we couldn't take it to court. They've done enough to kind of pacify it. Or it could be the investigation going longer than the 30 days. Maybe trying to give the parents a little bit more time, or being behind on steps to actually close it within those 30 days timeline. I will be looking at what else is going on and try to get updates if possible. But I will be, as I promised in my intro, doing some ramblings as well. So go ahead and leave me any questions you might have about child welfare or anything regarding the system that you would like me to explain. I work more on the side where the parents are working to get their children back. That's what I've been more specialized in, but I have seen all of the different steps, except we don't work too much with adoptions. Adoptions tends to be a more, I lost the word, a more specialized program, that at least work in my position where I'm at. I just hand the cases over to another worker and I don't get involved after that process. We are really big in the system about privacy, and not like we don't follow the families after they're left our desk. So I don't know too much about that process. I am able to answer general questions. So whatever you want, go ahead and leave me in the comments and I'll get back to you as I can. Thank you.